Have you asked the Home Secretary why the referral rate from police forces throughout the country so abysmally low to the CPS for rape allegations?
Well, it's up dramatically. So
a very small number, Lord Chancellor.
Well, no, you're right. And so that's why we are absolutely clear. Back in 2018, frankly, the system had a crisis of confidence.
I don't dispute all the things.
Yeah.
I'm just asking you whether you've spoken to the Home Secretary.
I speak regularly. So we have the.
So what's the explanation given for the abysmally low referral rate?
Well, I mean, I think it's very difficult. I mean, if you go back, and I don't want to name the person because he's completely innocent, but there was this case that you remember back in 2018, which we all know, right? And then there was a whole review about what had gone wrong in that case. And bluntly, there was stuff that should have been disclosed, digital material that was not disclosed, and we came within a whisker of a miscarriage of justice, which appalls us. Oh, and you know all that. So that was at least part of it. And then what we did is we set up this rate review where people would meet regularly, not just Secretary of State for Justice, but also the Home Secretary, to your point, the Police Minister, the Attorney General, the Solicitor General, to drive up every part of the system. And the final thing I'll say is getting all the data together, because the CPS gathered it in a different way, and then the Home Office and got it all together, published these scorecards and drove it up. And the key thing that we have driven up, and the steepest trajectory, is precisely your point, the number of cases referred by the police to the CPS for charge.
Do you think the magistracy send too many people to prison?
No, I don't.
Just a very straightforward answer to a very straightforward question. Can I just ask that was the point? Can I just ask you the question, therefore, that obviously the government extended magistrate sentencing powers, and then recently reversed this policy decision, and the minister cited prison capacity. Do you think the policy was reversed to fetter the discretion of magistrates who there was concern they were sending too many people into custody?
No, so let me be clear. I think the magistrates do a very good job, and as I've said earlier today, even though some people, it might be a fashionable view, you should get rid of all short sentences. Actually, magistrates acting on behalf of us, the public, sometimes have no option, even though it's a last resort, but to do that. And lest we forget, compared to 10 years ago, they actually send fewer people to custody in terms of short sentences than they used to. That is a fact. So it's not that issue at all. However, on the 12 months, there was a period in which that had taken place, and we needed to review how it had worked and not worked, and that process continues. Yeah, look, there's a context of prison pressure, but there is also a wider imperative to ensure that we take this in stages, and that's one of the data points that we need to consider. I just want to finish this point to say that I am absolutely in the market when the time is right and when it's appropriate to have 12 months before, but it's something that you've got to take in stages. And I pause to note that power to go to 12 months was in the Criminal Justice Act 2003, which Ms. Eagle will be.
I'm not criticising you at all. I'm just curious because you've said that part of the government strategy is trying to get the cases dealt with as quickly as possible.
Of course.
You're going to have more cases dealt with more quickly if you have 12-month sentencing powers. So it seems an odd decision to reverse that decision.
It is a really important. It's one of the factors that we have to consider, because you make a very fair point. And one of the things people have said to me, by the way, is have we got the line right in terms of either way offences? Is it right, for example, that someone on their fifth alleged theft from Boots should be able to elect a 3 or 4 day Crown Court trial and so on, rather than having it tried in the magistrate's court as a summary only matter? So all I'm saying is that these are things, of course, we have to consider in the round. We have to take account of the entirety of the context, which includes the caseload. It includes plenty of other issues, including pressures that you've alluded to and I discussed earlier, and we will consider that evidence in the fullness of time. And when it's right to do so, I do think, for the reasons that you've indicated, there is real merit in considering if we can extend that again.
We both practiced in the criminal courts for a long time.
Yeah, you still do.
The idea of delays is something that has happened recently. Yes, the pandemic has exacerbated that. Yeah. But there's been huge delays during the whole period when myself and you practiced in the criminal courts, always. And I think that listing is a thing where it's a curious. I've always found it a curious thing, and how it is organised and the considerations that are taken into account. I mean, there's a case today that's been. I won't go into the details of it, but a rather famous defendant has had charges, no evidence offered by the Crown Prosecution Service together. But as an example, and I don't think this is unusual, whether it's the pandemic or involving a man of some fame, it has taken from an arrest in August, I think 2021, to a second trial date in July, or potentially to the matter coming before the court in July 2023.
Yeah.
The original trial for a relatively straightforward matter of assault was months and months after the original police allegation. Now, I'm using that as a practical example on record because people have seen that case in the courts today. And I'm saying from my experience, that is typical, that straightforward evidential cases take months to list, and there is no good reason for that. And I just wonder whether you agree with that. And if that is the case, what are we going to do to make sure that these cases get dealt with far quicker?
Well, look, it won't surprise you now. I won't comment too directly on that case, other than to note that, as I understand it, I think a jury was discharged because they failed to reach a verdict in the first trial and had to then be relisted for a second trial. So it's important to know that there are two trial listings in that particular case, as I understand it, and then the Crown decided it was to offer no evidence in just before the second trial day. But you ask a straight question: do I think that effectively there is perverse listing? No, I don't think there's perverse listing. I mean, listing is a judicial function, and the courts need to take account of all sorts of, and you know this, and forgive me for telling you something you know extremely well. The first thing they've got to think about is CTLs. What is the situation in terms of their remand population, because they have to bring on a defendant within the 6-month time limit, or that person will make a bail application unless the Crown can show all due diligence and expedition or some other good and sufficient cause under the 1985 Act, then that person is going to be on their toes, and there may be good reason why they should be in custody. So they have to consider that. As to how they prioritise these things thereafter, the things that I would instinctively expect the courts to do, but ultimately it's a matter for them, is rape cases, for example, give those a fixture. Because victims, just a final point there, if you've got vulnerable victims, I would hope and expect there to be a fixture in those cases so that they're not gearing themselves up for the trial on the Monday, only to find, well, hang on, it's a floater, and it's all been stood out for a month's time.
Are you effectively saying, therefore, Lord Chancellor, that listing is a function of the courts, therefore nothing to do with me, and that there is no perverse listing? The listing process that we have is absolutely fine as far as you're concerned?
Yeah. This is an area where I have to tread carefully constitution because it is a function. That having been said, and this is part of my general point, it's one of those things which you can't measure, you can't put a limit, but if you have sensible, collegiate discussions with the judiciary, right? So if you have that meeting with the Criminal Justice Board and you've got the SPJ there and you've got the President of the King's Bench Division, these are the sensible, collegiate discussions you can have. I recognising what the constitutional boundaries are. They know what their constitutional boundaries are, but we can have a sensible conversation. Now, in the fullness of time, does there need to be discussion about listing as to the extent to which politicians can play a role? Fine, that's a debate one can have, but it's one for another day. It's one for another day, and I'm not kicking that one off just now.
Why do you think the number of duty solicitors is projected to decline by 618 by 2027?
Well, let me say, duty solicitors play a fantastically important role, and it was their fortunes and their future that was absolutely at the heart of the whole decision to kick off CLAR, which you'll know about. And it is so important for that defendant, as he's coming into the police station, he's got to be represented by we need him to be represented by somebody who's experienced, who understands what is correct and fair advice to give to his client, and that will assist the administration of justice. And that's why, if the CLAR, or if and when the CLAR reforms are at full effect, we'll be looking at duty solicitors getting up to an additional 30% for police station work.
The question I asked.
No, I know. So that I just want to make this point, yeah. And for a magistrate's court work up to additional 20%. And as I say, it's absolutely at the heart of the reforms, as part of over £85 million going into the solicitor's profession. So you asked the question of why the numbers are projected to go down. I think the best answer I can give is to address the issues which are under my control, which are to ensure that the people are properly remunerated, that the court estate is properly maintained, and we put an additional 135 million and then additional 30 million, and then I want to go further still. So those are all the things that are under my control and that I'm pushing, and I also want to just send out a message. Legal aid solicitors and barristers will be always respected by this government. We're not going to go down the ridiculous rabbit hole that others did of boasting that they were going to derail the gravy train of legal aid or trying to name and shame them. None of that. We respect them and we want to reward them.
One of the things I find curious in my experience of the justice system is we have reducing numbers of everything, it seems, apart from police officers, which I fully accept. First of all, I think you've confirmed already. Have you said that the target of 1,000 new judges has been met?
So let me. Do you want me to? So 22-23, we over-recruited. So there were 990 vacancies, and we recruited around 1,000. So yes, over-recruited by.
But do we need more judges to allow the courts to run at full capacity?
Yes, we do. So the 2023-24 programme is for around 1,000 vacancies, but that's across jurisdictions. So
are you as part of your? I don't know whether it's a daily report that you get in terms of the figures coming back to you.
Yeah.
Do you get a flavour or the specific figures to how much of the court estate or how many courts in percentage terms are not being used on a daily, weekly or monthly basis? So can you just give us an idea of the figures that they...
Well, so as I say, we effectively said full tilt, use courts to the maximum capacity. In terms of maintenance issues, we lose about 0.5% of sitting days due to planned and unplanned maintenance. So that basically is the figure. Now, the wider point is we need to increase the pipeline of practitioners, because you've got to make sure that there are people there to prosecute and defend these cases. And indeed, I declare it some way. My wife's a practitioner, and she's told me there'd been a case. She's a civil practitioner. Sometimes a case has been stood out because there isn't a judge. That is something that practitioners will be familiar with. That's why we have to recruit. So, look, I mean, the general point is this. The system is delivering more justice, but there is a caseload as we heal from COVID, and we're ramping up that capacity to do it. It will do it, and it's healing well. We have phenomenal practitioners in this country. We have phenomenal judges. And it is, the system is healing and progressing well. But it's not something that happens overnight, and you have to do some of the boring plumbing, as putting the arrangements in place for remuneration, having these proper relationships, getting more capacity in the courts, more sitting days, and to improve that, to accelerate that process.
I'm sure that when the chair was practicing, and yourself,
yeah,
I can't remember a time where it was a reasonably regular occurrence that a prosecution barrister could not be found for whether it's a matter of rape or a matter of serious sexual. That just did not happen, and you knew that didn't happen.
Well, no,
and for some reason it's happening now. Why?
You know what? You're right. I've never known a time when there were 60,000 cases in the caseload in the Crown Court. So that is the fundamental difference. So if you look at the number of cases in the Crown Court, so say in 2010, it was about 48,000. Just before the pandemic, it was 39 to 40,000. It's now 60,000. I mean, that is the fundamental reason. And so and there were those who said during COVID, and we all asked ourselves these questions as a system. Hang on a second, should we just basically bin juries? It was a question that was asked in other juries. It was asked in Scotland. People were talking about it here. Should we effectively just have a sheriff's model? We decided not to do so, because if you wash away that line in the sand, it's very hard to put it back in the sand. It is a totem of the lamp of our liberties and so on. But there is, to some extent, there is a price you pay for principle. And that's why there isn't particularly the issue in respect of 90% of cases, right? 90% of cases in the Magistrate's Court, there is not this issue to anything like the same extent.
There's too much work. It's too many people.
There's a lot of work. There's a lot of work in the system.
I'll tell you what, Lord Chancellor, my final point in respect to that is the police actually charged. Most charging out rates...
This is your favourite point.
Well, most charging out rates in this country for offences are well below 10%. If we actually charge people at a proper rate, the amount of work coming through the court would be monumental compared to what you've got now, and therefore if we can't deal with what we've got now compared to the number of cases, I think we've got some problems.
It's apples and pears, because as you say, the overwhelming majority of what they do charge is in the Magistrate's Court, and the Magistrates are operating at about 120% of their pre-COVID capability. So they have switched it on absolutely dramatically, and it's worth listeners of this realising what that means. That means common assaults, that means ABHs, that means Section 20 GBHs, that's burglary of non-dwelling burglaries, it's TWOC, it's dangerous driving. It's so much stuff is dealt with in the Magistrate's Court which affects people's lives, and that is, that's going very well.
You said, and forgive me if the terminology is wrong, that the IPP is a stain on the criminal justice system.
Yeah.
Recent prison population data shows that on the 31st of March 2023, there were 1,355 offenders serving an IPP sentence who had never been released from prison. Of those, 641 people had been in prison for more than 10 years longer than their tariff, including 189 people whose original tariff was less than 2 years. Do you think a political system should allow somebody who's received a 2-year tariff to potentially serve over 40 years in prison?
I have probably said more lurid words of condemnation about IPPs than any other Secretary of State. I think they were I reiterate that they're a stain on the justice system and a stain on the conscience of the justice system. The really difficult, and I should say, by the way, I've read your report, which I thought was very interesting. We'll go on, no doubt, to talk about some of the recommendations in it. I'm particularly interested in recommendation 8, which the government initially opposed, and we'll just have perhaps a discussion about that, if that indeed is your will. But I just want to say that, just stepping back for a second, the difficulty for a Secretary of State, who of course has to keep the public safe, is you've got this conundrum that people who were deemed dangerous in the first place, in other words, a judge was satisfied that this was a qualifying offence and this person was dangerous, either because it was a particularly appalling knife point robbery and so on, then because they've remained in custody, potentially that has damage some individuals, bluntly, because they've not got out each time. There's a sense of hopelessness, and yet that person can potentially become more dangerous as a result of what has taken place. Now, that is a matter of injustice, but it also means that if that person is out on the street, that potentially causes risk to your family or your parents or your children, and so that's something that has to be considered. But we have a solemn duty to do everything we can and to devote the resources we can to try to ensure these individuals can progress through the justice system whilst never losing sight of our duty to protect the public. And that's why, we've got this action plan which we can go through in as much detail, but effectively it's got 4 principles, 6 work streams, but boldly and bluntly, the aim is to reduce the number of people serving an IPP sentence, and I'm interested in some of the recommendations in your report.
Well, I think you've just touched on the point that I was going to make, that there is very clear evidence which is contained within our report, and I think from every professional body who's been involved in this, that mental deterioration with the nature of this sentence is linked very closely. Yeah. What my concern, Lord Chancellor, is that we are getting away from people being a threat to the public and keeping people locked up because they've got mental health conditions. And the differential between those two statements is perhaps a nuanced one, but I don't know whether you agree with me or not. I think some of those 1,355 offenders are not a threat, and I think they are in there because of the impact this sentence has had on them, the mental deterioration it has brought, and we cannot surely be in a position where, because people are unable, without, I don't know how to describe it, people who, because of, I mean, it's stark. If you're in prison for 10 years longer than you tariff, it's bound to have an impact on you. You're not going to be a person who is, how can I put it? I hesitate to say this, but normal in the normal sense of it. You're not going to be able to go out and just suddenly walk into a job and everything's going to be all right. And that really concerns me, Lord Chancellor, that we are locking these people up because they've got mental health problems rather than them posing a threat or a risk. If you've been in prison for over 10 years longer than what the original sentence should have been, I cannot see where the threat to the public comes from that.
Yeah, well, I agree with the thrust of what you're saying, but I have a slightly different view on the details. So it is certainly the case that having people serving 10 years over tariff is very concerning to anyone who's got a basic sense of right and wrong, point 1, I think. But point 2, on the issue, I agree that plenty will have mental health problems. Point 3, I accept that those, in some cases, a lot of cases, may well have been exacerbated by the experience that they've had. Where I depart from your logic, however, is sitting here in the Grimond room in Parliament to actually form a view as to whether that person is or is not dangerous. Now, that has to be a decision for the professional parole board, considering psychologist evidence, psychiatrist evidence, their offender management evidence. And what we cannot avoid is that the judge at first instance decided that person was dangerous, and bear in mind that was on the basis of psychiatric and probation officer evidence whenever it was in 2004 or whatever, decided that person was dangerous, and that each parole board review, the parole board has decided that person is not safe to be released. What I cannot do is supplant my judgment for the judgment of that problem. So, but that is not a counsel of despair. Okay, that's not a counsel of despair. That's not me saying, okay, well, brilliant. Well, it's just one of those things. We'll just have to let people suffer and cuss it. No. But you haven't let me finish. That's why I'm absolutely determined that you've got to get them in a position where they are safe to be released with an extremely aggressive and intensive plan, this action plan, with its 4 principles, with its 6 work streams, not just about publishing data, but ensuring that every IPP sentence prisoner has a sentence plan It's not just saying, broadly what needs to happen, but specifying the particular interventions that are required to reduce the risk in that particular case. And not just that, to ensure that when they come out, they are getting the support so that there isn't the merry-go-round to go back in. Because as you rightly pointed out, there are more now people on recalled IPPs than there are on original sentences.
You see, again, that's where... just one more question. Yeah, sure. But then that, again, the recall is again, a fault within the system. And we've heard evidence in camera and out of it that when these people are released, the conditions that are put on them, in many cases, don't have any relationship to the alleged threat they pose to the public. And when you're somebody who has been in prison for a long time comes out, it is a difficult transition for them, let alone whether there's a threat or not, to actually survive in society. Now, if you're asking people to report regularly to a police station or something else like that, and they're not able to do that because they have not yet developed those organisation skills or human skills because they've been in prison for a long time, we are sending people back into prison who are not actually committing further offences and are not posing a threat as a result of that. And again, that's how can we do that?
I think it's very dangerous there are issues with generalising. I understand why you make the point as you do. But this goes back actually to an earlier conversation we're having about probation officers. It's when you skill up those probation officers to make sensible decisions. So if that person missed that appointment, is that genuinely reflecting a risk that this person is about to go and knife someone? Because if they are, they should be back inside, I'm afraid. We have to keep the public safe. Or is it because, actually, do you know what? The relationship, they haven't rekindled their relationship on the outside, but actually we can stabilise it, or there's an issue that they haven't got their mental health treatment or their medication in proper balance, and so they can take a view. That requires finely balanced decisions. But if I may, I do just want to address, if you're interested, where I think we ought to, there is stuff for us to think about carefully. In your recommendation 8, you were looking at the fact that at present, after 10 years, it used to be the case that they would have to apply, but now there was an automatic referral for 10 years for consideration. Now, one of the things you suggested, or whether the licence should be dropped, because it hangs over people like a sword of Damocles, and people can't, and that's about the hopelessness thing. Like, even if I get out, this is going to be hanging over me for 10 years. I might be dead then. They want to think that they can get past it. That's an important part of it. And so, one of the things you recommended in your recommendation 8 is, look, is that period too long? Should it be 5 years? And I want you to know that I'm looking very carefully at this. It's something that was initially rejected. It does seem to me that there is merit in what you have written as a committee, if I may respectfully say so, and that is getting a very careful and developed consideration. I think it's probably as far as I can take it.
I think we're